Hi, and welcome to the video for chapters 16 and 17, dealing with legal memoranda, which is the plural for a memorandum. We are going to talk about what the purpose of a legal memo, the structure, the format, and that will be the last assignment that you will submit. It'll be your final, is the legal memo dealing with Mr. Morgan and what would be the likely outcome of him being charged with burglary. So let's move forward. What is an office memorandum? It is an informative document that is going to summarize the research that you do with a particular client's problem, and then an analysis of what you found in your research as applied to the facts of our client's case. And that memo is going to then go to your supervising attorney. Your supervising attorney will request that you research a certain area of law and then convey to them, communicate to them what you have found through your research. And you need to address both anything you have found positive for our client and negative. And usually it is going to be presented in a specific format. And it's really important to get that office memo correct, because it is going to be the foundation for every document that you do in the future with regard to this particular case. It's the foundation of all the documents. So you need to be as thorough and as efficient as possible. So you also are going to need to analyze both sides of the issue. You're not just going to look at what's good for our client. We're going to look at both sides, and we're going to use this document. It could be used to decide whether or not we actually want to represent this particular individual. It's going to help us in preparing future documents. It could be that we determine, based on what we found in our research in this memo, that we need to, push to try to settle this case. It can be really the basis for every document that comes afterwards. It is a research document. You're doing the research, finding the information to provide your supervising attorney so that they can make intelligent choices and decisions about this particular case. You want to find what is the applicable law, what governs this particular issue, and how does that law apply to the facts of our particular case. Looking at the weaknesses and the strengths, you want to come up with a conclusion based on this analysis of what you predict that the court is going to do. Office memos are called predictive writing. You're not trying to persuade your supervising attorney about the case. You're trying to give them all the information that they need in order to move forward, whether that be to settle, to file the case, to accept the person as the client, whatever it might be. It's the basis for future decisions. It's an internal document, so no one, no one else is going to see that. And you have to be objective. You have to look at everything from both sides and not try to argue on behalf of the client, which is hard for us. If we have chosen to be in the legal profession profession, it is second nature for us to want to argue on behalf of our client, argue on behalf of the facts that we are working with. And so you have to, in a memo, be objective. And sometimes that is difficult for us. So, as I've said, this document is the foundation for everything that goes after it. It's a guide for what course of action we're going to take. It is going to refresh the attorney's memory about what's going on with this case. It's going to be the basis for all future documents. It's extremely important. Okay? You are going to need to identify any required elements of this particular issue. If it's a cause of action, what are the elements of the cause of action? If we are defending, if we're on the other side, what are the elements of our defense? It's going to inform the attorney on what we need in order to support or oppose a motion that's been made. It might have within it recommendations about what discovery we need to conduct, what additional information we might need, what evidentiary issues we might have at trial, what could possibly be post-trial issues. So anytime that you are drafting a legal memo, you have this dichotomy of this tension between being accurate and being economical. You can't, spend days and days in research, especially if it's a rather basic ip if the client doesn't have a lot of money. You've got to balance that time and money, but yet you've got to get the correct answer. So when you are drafting a memo, you're going to do a good bit prior to actually writing. Okay? You want to determine, this is in that pre-writing stage. We talked about this in the letter writing. You're going to have that pre-writing stage where you want to examine the nature of the assignment, the nature of the case. Do you understand what the attorney is asking you to do? Do you understand what type of legal writing is required? Do you understand who is our audience? In an office memo, it's just going to be our attorney or the team that's involved in this particular case. What are the constraints on our assignment? Are there time constraints? Meaning, do we need to, do we have a statute of limitations that's looming? Do we need to make a decision within the next couple of days about whether to move forward or not? What are the constraints? What's the format that the attorney wants us to use? And that can differ from office to office and from attorney to attorney. So you need to make sure that you understand how they want the document drafted. You want to conduct your research with your memo in mind, what you've got to present to your attorney. As I've said previously, always keep a documented trail of where you've been in your research so that if you have to return somewhere, you can easily do it. Use tables or some other organizational classification so that you can keep track of the cases and the statutes. Print out your cases. Don't try to read things on a screen. Print it out. Highlight it. If you're If you don't have a printer, if you must look at things on the screen, create hyperlinks within your document. All things to help you organize your research. Then you want to think about your audience. Your supervising attorney is extremely busy. He may have 2 or 3 paralegals working for him, and they're each working on 2 to 3 cases. So you've got to draft your document clearly and concisely. Be professional in your tone. Always, always make sure that you have allocated enough time in your time schedule for proofing. You've got to be able to walk away from it for a while and come back and proof it. Use plain language. Try to avoid wordiness because that can confuse the points that you're trying to make. So we've already said, be professional in your language. This is not a good start to a memo. For starters, let's decide if John Doe's parents are immune from suit. You want to be a little bit more formal than that. The first issue is whether John Doe's parents are immune from suit. Use simple, direct words and sentences. Be objective. I cannot stress this enough. No, I believe, I feel. You're not giving your opinion. You are predicting what the court is going to do based on valid research and analysis. Be specific, be complete. So the format for your memorandum, you're going to have your heading, which is traditionally what you'd see in any memo. That's going to be your to, your from, your regarding or subject, and your date. And the date is important because you are stating that that is the law as of that date. You're saying, I have done my research, I have shepherdized the research, and this is the standing of the law as of this date. You may, or your attorney may, request that you include a statement of assignment section. Just a short sentence or two reminding the attorney what they ask you to do. Your statement of facts. Remember, we've already spent time talking about the statement of facts. Here's where you're going to have your key determinative facts. Those things that if we changed could change the outcome of the case. Or background facts that we need to have in order to understand what happened. Then you're going to have your issue or question presented, and you could have more than one. You're going to have a brief answer to that issue, one sentence, brief answer that you're then going to address more in depth in your analysis discussion section. If you are dealing with a particular statute, you might want to quote and have a separate section for the statute. Then you're going to have your analysis, discussion, application section, whatever you call it. This is going to be the section where you're going to take what the rule of law is and you're going to apply it to the facts of this case. And then your conclusion. It's going to be a little bit more in depth than the brief answer. You're going to summarize that analysis and give a conclusion. This is a document that's going to be useful now with this current client, but it also might be useful in the future, not only for drafting future documents, but for also, you know, you might have a similar case to come along a year, 2 years from now, and you can go back to that memo and the research that you found and simply update it with a new set of facts or the new client. So you want to, in this, identify the file by name and number, however your particular firm identifies files. Identify the topics or the topic. Identify yourself and the recipient and the date. All of that's going to be in the heading. Okay, so here's the example of what a heading would look like. To Larry Lawyer, from Patty Paralegal, regarding Kathy Client, the file and the file number, and the date. The statement of assignment. As I said, give your attorney just a little clue as to, refresh their memory about what they ask you to do. So you're giving just the parameters of the assignment as you understood it. So now we're going to go through the other sections, and there are a couple of ways you can do this. Some people will put the statement of facts first and then the issue, and then others will do the issue first and then the statement of facts. I tend to like it with the statement of facts first. That's just how my brain works, but I wanted you to understand that your attorney might want you to put the issue first and then the statement of facts. So your facts: what happened, who's involved, when did it happen, only the legally relevant facts. Don't have argument, conclusions. If there is some procedural history, you'd want to put that in there, but if you're just getting the case, the client's just coming to us, it's probably not going to have any official procedural history unless they're changing attorneys and the lawsuit's already been initiated. Usually in your facts, you want to either organize them chronologically or topically or some combination of both. Don't leave out the things that are negative for your client. You've got to present everything. And if there's some dispute about the facts, is there a dispute about whether or not our client or the defendant ran the stop sign, we need to include that in our facts. That first paragraph of the facts should identify your client, the legal problem, and the relief that is being sought. Then you're going to move into the question presented or legal issue. There you're signaling to the reader what's the law that applies, what's the precise legal question, and which of the significant facts actually apply here, or the law is going to apply to them. This is where you want to use that under does when formula if that speaks to you, if it works for you. You want to make sure the issue is correctly identified, completely and correctly stated. If you have multiple issues, you want to address them separately. The question presented is setting forth what is going to be addressed in this memo. Okay? What's the primary legal question that's arising from the situation? Okay, so you want to use a question format in a neutral voice. Is the contract between Mr. Smith and Mr. Jones valid under the statute of fraud? Or you can use just whether the contract between Mr. Smith and Mr. Jones is valid under the statute of frauds. Or whether does win. Whether under Georgia law does an individual commit fraud when he signs someone else's paycheck, even if he has the account holder's permission. So those are several ways it could be drafted. Keep in mind, it does need to be in a question format. You then have your brief answer or short answer, very brief, precise answer to the issue, and a brief statement of the facts and reasoning in support. Okay, 1 to 2 sentences. Here's a good brief answer. No. You're answering the preceding question or issue. No, the contract between Mr. Smith and Mr. Jones is not valid because the contract involved the sale of real property and there was no writing to evidence the agreement. The statute of frauds requires contracts relating to the sale and purchase of real property to be in writing. You're then going to move into the discussion, analysis, application section. I skipped. If you've got an applicable statute, you might want to quote that out. But then to your discussion, analysis, application. This is the long portion of your memo, the substantive portion. You will analyze the legal issues as they apply to the facts of the client's situation. You can't just find cases in your research and then summarize them. You have to draw similarities or differences between our client's facts and the cases you found in your research. Why do these cases apply? Or why do they not apply? If there's more than one issue, you might want to have subheadings within your analysis section. Use proper Blue Book citation format for the sources that you are relying upon. Okay, in your analysis section, you're going to do an IRAC within that analysis. Okay, now I'm not telling you you've got to label out the issue, rule, analysis, conclusion. I'm just telling you that's the method, the organizational structure for your analysis. The discussion, analysis, application is, as I said, the substance of the memo, the actual body. Here you're going to identify the research you found. You're going to quote from it if need be. You're going to relate that research to the client's facts, okay, and look at the issue from both sides. If you are using a statute, you want to introduce that statute. You want to paraphrase or quote it as relevant as it's needed. If there's more than one, you want to present them in a logical manner. You want to cite them properly. If you're relying on case law, you want to look at, does the rule of law in that case require some interpretation? Can it be applied directly to the facts of our case without interpretation? How are you going to present it? Don't just quote and then not draw a conclusion from the case law to our client's facts. It's more than simply finding the research and then regurgitating it back. You've got to show how it applies to our client's facts. Why is it applicable? Why should we look to this case as being something that our court is going to rely on and base their decision on? You've got to provide that counter analysis, the counter argument. You can't just present what our client's side is. The attorney needs to have the information and the research to rebut the argument from the opposing counsel. So, which one do you present first? Well, you're going to usually present your client's position first, then the information on the counter argument. And if you believe that that counter argument can then be countered by something else on our side, you want to present that information as well. Next you have, and finally you have the conclusion. It's a summary of what you found in your research, what you've determined from your analysis of the research and applying the rule of law to the facts of the client's case. You're drawing a conclusion. It's going to have some of your opinion in it, but that opinion is based on the legitimate sources of law that you have found in your research. No citations in the conclusion. It's going to be very clean and concise. So, you might also have, and the reason I have this in italics, the things that you may or may not have in your memo, depending upon your supervising attorney, your recommendations, what the next step should be. Identifying, maybe there's additional information we need to go back to the client and get, or we need to do some investigating in order to find information. Any additional research we might need to conduct, or maybe we've identified another issue through this process that the attorney needs to address, not just the original issue. Don't use first person, okay? Don't say things like the next case I found or I believe. Don't just quote from a case unless you have introduced it or summarized it to the reader. You can't just quote from a case and not give them the background, the reader the background that they need in order to understand how this case is similar to our client's situation. Use correct Blue Book citation format. The things that you would be in this final assignment working on or citing to would be simply the cases and the statute, and you can find that formatting in your text. You don't have to get the Blue Book. You can find that format in your textbook. And keep in mind that whenever you start a new project, you might want to go and check if the firm has a memo bank of previous memos that have been drafted, and possibly someone has already addressed this issue and you'll just have to update the research, shepherdize the law that's been found, and do minor editing. Sometimes the attorney is going to want you to copy the cases that you found in your research, or if everything is being transmitted electronically, your memo, they may want attachments of the cases. If they might ask you for your case briefs, then you might want to attach those. Keep in mind, always have everything together before you start writing so you don't have to stop and go find that case you read. You want to have it all together with you. Always shepherdize or key cite the cases and the law, the statutes, the primary law that you have found, so that you can be sure, or the attorney can be sure, that this is the current status of the law. You don't have to shepherdize for this memo assignment that I've given you for Mr. Morgan. I'm just telling you that's the law. You don't have to go find any additional research. That's all that you have to rely on. Okay? And if your firm doesn't have a memo bank, you begin your own so that you can have them in the future. So just a few other things I want to say to you about this memo. It should not be more than 5 pages. Probably it's going to be somewhere around 3. And we will, in that last class, we will review. If you've got a rough draft at that point, then I can give you some pointers on how to update or how to streamline your process to produce that final document.